Good morning, everyone. This is Monica Rafak. I'm Deputy Commissioner of Human Resources for the Department of Family and Support Services. I apologize for the delay in starting. We had a little technical difficulty, and the weather kind of slowed us down over here, so I apologize for the late start. But I don't think this webinar will go the complete time, so I'm going to try to have you out of here and done with this in a timely manner. Today's topic is Family Medical Leave Act, and up on the screen I have what we're going to be covering today in the webinar. I do want to tell you that Family Medical Leave Act is somewhat of a liberal law for employers and employees, mostly for employees. So I also want you to be aware that there's resources out here. I'm just going to cover basically the overarching topics. If there's specific questions about your agency or things that you've done with FMLA, I urge you to look at the federal government website, which I will share with you in one of my documents. Because everyone there are some choices when administering FMLA that you can utilize rather than not everyone, not everyone administers it exactly the same way. Being part of the City of Chicago, we have a few processes that we must follow. So what I'm going to share with you today is kind of some ways to keep that very consistent and to make sure you're managing FMLA as best as possible. So what we're going to cover today, we're going to first define what FMLA is, who should be offering FMLA, who is eligible, or the eligibility of FMLA. We're going to talk about some frequently asked questions. And then I'm also going to share with you required forms that are also available on the website, as well as some sample forms that we use here at the city that you may be able to utilize in your own agency by tweaking them to utilize under your umbrella or with your letterhead and things like that. Also, we're going to talk briefly about the tips for administering FMLA. So I want to get started by exactly what Family Medical Leave Act is. FMLA requires covered employers to provide up to 12 weeks of unpaid job-protected leave to eligible employees for the following reasons. And as you can see, there's a lot of reasons underneath. There's various conditions, oftentimes due to pregnancy, after a child's after birth or placement for adoption or foster care, to care for an employee's spouse, son, daughter, parent who has a serious health condition, a serious health condition related to the actual employee. A newly formed reason for allowing an employee to be on FMLA is for employees with a spouse, son, daughter, or parent on active duty or call to active duty status in the National Guard or Reserves in support of a contingency operation may also use this type of leave to address certain qualifying exigencies. FMLA also includes a special leave entitlement that permits eligible employees to take up to 26 weeks of leave to care for a covered service member during a single 12-month period. For those reasons, I urge you to go to the government, the federal government website. I have not actually had that experience with having an active military member or someone who needed to care for one, so I have not really had to engage in that type of leave for an employee. But as we see the military and things like that, and many more people and troops coming home, you may see that a little bit more. So what employer or businesses must offer FMLA? Well, here's what the federal government says. Public agencies, including local, state, and federal employers, and local education agencies, which are schools, and then private sector employees who employ 50 or more employees for at least 20 work weeks in a current or preceding calendar year, including joint employers and successors of covered employers. So, eligibility. What type of employee is eligible for FMLA? In order to be eligible, you must work for a covered employer. Obviously, those categories that I just spoke about in the above section, you need to be part of an employer that falls in those categories. An employee must have worked 1,250 hours during the 12 months prior to the start of leave. So I have had experience where an employee has started with us and 5 months into their employment, they are pregnant. And unfortunately, that employee was not covered by FMLA. So they have to be at least in your employment for an entire year. That's another, and unfortunately, that's just how the law reads. So we were not able to provide that employee with FMLA. So you also must work at a location where the employer has 50 or more employees within the 75 miles within that employment location. Have worked for the employer for 12 months, like I just stated. The 12 months of employment are not required to be consecutive in order for the employee to qualify for FMLA leave. In general, only employment within 7 years is counted unless the break in service is 1, due to an employee's fulfillment of military obligations, or 2, governed by a collective bargaining agreement or other written agreement. So that's kind of what we're talking about, eligibility, and some of that kind of probably sounds like legalese to many of us, but actually that's really taken directly from the law. So after talking with that, we talked a little bit about, who should be offering, and then the eligibility. So we did talk about the eligibility as well. And what I want to move to is some frequently asked questions that occur often when dealing with FMLA. So many times people or employers are wondering, does an employee have to use paid time concurrently with FMLA? Actually, majority of employers require employees to use their paid time concurrently with their FMLA. So you have 12 weeks. Let's say an individual is taking a block of time for 12 weeks. They're having their first child. So most employees require that employee to use all their either vacation, sick time, or a lot of companies call it paid time out, PTO, and they run that during the 12 weeks. Some companies don't require that, and an individual may be able to take, a complete unpaid leave. But as you may or may not know, what this allows an employee to do, whether they're getting paid from their paid time in the bank, or if they're taking this unpaid leave, what this also allows is an employee to maintain their employment status with the company, and it also allows an employee to pay their medical benefits at the cost that is offered to them when they are working full-time. So that's huge, because a lot of employees, if they're in an unpaid leave status not covered by FMLA, they typically have to pay the full amount that is covered by benefits. The other thing is, if they're not covered or they don't take FMLA, there is no requirement of the employer to provide them their job back after they come back. Again, you have to remember, if you're covered by a collective bargaining agreement and if you already have rules set up, you should follow those first. For the city purposes, we have a couple resources that we have to look at before we can say an individual is allowed to go on an unpaid leave. But FMLA, as long as they meet the general requirements of the eligibility, which again, I don't think I went into the full amount of the eligibility, but remember, you have to work for the covered employee, and you have to have worked 1,250 hours prior to the 12 months. Those are huge, huge, the two criteria that allow people to be eligible for this leave. Another frequently asked question is, when you're counting the 1,250 hours for an employee, you have to remember that unpaid or paid leave such as sick time or vacation time is not counted into that 1,250 hours. You must only count actual work time. So if an individual, prior to wanting to take FMLA in the preceding year, has actually took a 3-week vacation, which that doesn't happen too frequently these days, but let's say someone was going overseas or something, they needed their 3 weeks, those 3 weeks would be deducted from that 1,250 hours. So that could affect if they're covered by FMLA or not. So you have to run it, you know, a year prior to when they're asking for that time to be started. Again, qualifying conditions, there's several reasons. When we go through documents, you'll see that there's certification forms that need to be completed. And without those being completed, those are kind of your catalyst to know if an individual has a serious medical condition. If a doctor is not signing off on those documentation, or you don't get all the proper documentation, my recommendation is that you know, you have to go back to the employee and allow them to be able to turn in the proper paperwork before agreeing to approve FMLA. You should never pre-approve anyone for FMLA. You need to make sure that they have all the documentation in order to approve them. The other issue, now we talked a block of time for FMLA. That's when someone wants the 12 weeks in a block of time. There's also intermittent leave. So this is someone who may have a serious health condition for themselves, or they're caring for someone who has a serious health condition, and they need scheduled time off during the week in a non-block of time. We call that intermittent FMLA. So 12 weeks equals 420 work hours. That's for the city, and I think that's across the board through the federal government. So I'm going to use myself as an example. I was in a car accident, and I hurt my shoulder, so I need therapy for 6 weeks. And I need every Monday, Wednesday, and Friday in the morning off from 9 to 10, because that's the only time I could get my therapy for my shoulder that I hurt in the car accident. So what I would do is I would take the same documentation, which we'll go through shortly, and I take that to my doctor who fills out the certification, and there's areas where it is checked off for the full 12 weeks, or if you're asking for intermittent. I would put in there that I need 3 hours a week for, or he would actually mark it, 3 hours a week for 6 weeks. And then I would propose that to my supervisor by saying, you know, I need this time, it's covered under FMLA, I have the documentation. The only real concern all of you need to be sure of is that employees and their supervisors should not really be talking about the health condition. They are just talking about the time off they need. So supervisors, unless they're also the HR director, should most definitely not be talking conditions with their employees. It's basically just about the time off. And when we kind of go through how you administer this with your employees, I think you'll understand how you can manage it without talking about actual conditions. You're just talking about the time off that the employee needs. You're notifying their supervisor that they're on an approved leave, FMLA leave, and you're also notifying the employee. But you have to really make sure that you're maintaining and tracking the time that these individuals will be off. Another example that we've had in our department is someone who is going through cancer treatment. Now that can last a lot longer than therapy, and that's a way for someone to really eat up their 420 hours, which also may affect if, God forbid, the following year the cancer resurfaces, that can affect if they're covered by FMLA in the following year. So there's a lot of different things that you need to take into consideration when administering FMLA. Again, when we go through the website, when I give you the website, which I can give you now, we're going to talk about tips for administering. But when you visit, it's www.dol.gov/WHD. And it's on my tips, which you can print out. You can print out all this information. And I think I can forward most of these documents to all of the agencies as well that you can use. But that is an excellent website. It's from the federal government. It has, a majority of questions and concerns that have come up over time. Additionally, you can also reach out to the federal government, and an expert on FMLA can either come out if you have a group, if you're one of the larger agencies with supervisors that want to hear exactly how to administer FMLA. We have had that at our city meeting where a representative from the federal government comes out and kind of talks about this very general toward your organization, which has been very helpful in the past. Again, I'm not considering myself an expert, but I have had, along with my assistant, Sue Gomez, we have seen many cases of FMLA. We've had to, go back to our law department to find out if certain cases were legitimately covered under FMLA, circumstances. You also have to be aware of the employee who may take advantage of FMLA. Now that can become a slippery slope in terms of how you manage that. Again, as I started with the webinar, we talked about FMLA is a very liberal law that errs on the side of caution, and it typically errs on the side of employees. So I would highly recommend, if you're going to deny someone for FMLA, you first, of course, look at the Department of Labor website, but if you have also in-house counsel or attorney, you would also talk through with them about what the effects of denying an employee for FMLA. So again, serious health condition. Let's move on to that a little bit. What constitutes a serious health condition? So the most common serious health conditions that qualify for FMLA are, again, anything that forces an employee to stay overnight in the hospital or other medical care facility, conditions that incapacitate you or your family member for more than 3 consecutive days, or have ongoing medical treatment, either multiple appointments like we talked about, if you have therapy, a single appointment, and follow-up care such as prescription medication. Also covered is chronic conditions that cause occasional periods when you or a family member are incapacitated and require treatment by a healthcare provider at least twice a year. And then, of course, the most common use of FMLA is pregnancy. So that's also, for obvious reasons, people who need to take off either to have the baby or they're having a pregnancy that is high risk. Okay. Again, in the certification piece, one of the questions always comes up for an employee: am I required to prove that I have a serious health condition? Absolutely. There's some timelines that you want to ensure. Again, when we go through my packet that I'm going to show all of you, you will see how we administer FMLA to our employees. We set timelines, deadlines, so that you don't have FMLA packets out there wandering. You kind of can close the loop. But an employer may require that the need for leave for a serious health condition of an employee or the employee's immediate family member be supported by a certification issued by a healthcare provider. The employer must allow the employee at least 15 calendar days to obtain that medical certification. So that's where the timeline kind of comes in, and where you need to focus in on that. So again, on this website that I talked about, there's many questions and answers that I think all of you can look up and take a look at if anything is relevant to your employees. We have also, our other document that I've included for the webinar is a fact sheet about the Family Medical Leave Act, and that's also a very good resource that you can see on the screen here. I pulled it off the website as well. We use it, but this is a quick reference for all of you, and this is really summarizes kind of everything that we just talked about. So you really need to take a look at this, and this could be part of how you set up your process for administering FMLA. What I want to go then into is our leave packets. So if Victor would be so good as to pull up, let me see which one we want to pull up. This one here, the memorandum, the samples. Actually, you know what? Go back one, I'm sorry. That far right hand, the FMLA request, yeah. Okay, so this is a sample packet of what we give to our staff. First and foremost, we have the employee fill out this form so we know that they're requesting FMLA. And this kind of starts that 15-day clock. So when they ask for it, you know, we have a record that they have requested it. Again, this is all, you can use this as a sample. Of course, I need to take off Family and Support Services when you do it, but this is something that you can create for your own process if you do not have one already. If you go to, if Victor scrolls down to the next page, then we have exactly what we're doing here is kind of telling the employee what is FMLA, okay, and what they are required to do, what they have to read, the conditions of FMLA, how to process and return to work, and who the contact is for FMLA in our department. Suzanne Gomez, who is here in the room with me now, she handles the majority, and I am the backup. You know, I supervise Suzanne, but she's our first point of contact who actually puts these and keeps excellent records on who is out, who is on, you know, back in, who's on intermittent FMLA, who is on a full leave, and we do monthly reports on that for our executive level. Because I can tell you with the size of our department, FMLA, you know, you're going to have a percentage statistics just say that go on FMLA. So it's good to know who exactly is coming and going, and it's always helpful to know, you know, how long these individuals, because it is what it is. We have to give it, we have to allow people to be out, but it can affect our work as well. So we want to make sure we're managing it, you know, the best possible way. So that's also a sheet that you can utilize. The next sheet, again, is to maintain information for the employee requesting FMLA. If you can see, we ask them for their name, title, all their pertinent information. And then below, when Suzanne is meeting with them, we ask kind of what they're looking for, if they're looking for intermittent or if they're asking for a leave of absence, because that really kind of tells us what we have to do paperwork-wise to allow an individual to be out either intermittently or on leave of absence for a solid period of time. So we keep that into the file. We also give, if you scroll down a little bit more, we also, here's the thing, I know you all may be thinking, oh, this is a lot of repetitive information we tend to give out to our employees. But we have found that if we do not, we have employees who come back and say, I never saw that, I've never signed that, no one ever told me that. So we kind of try to give our employees every which way we can. So this is the actual handover of paperwork, but we also tend to follow up in emails and communication any which way we can. So again, this is kind of a summary of the basic entitlement, leave entitlement, who's eligible, and this came again directly from the federal government website. Our next page in the packet is Family and Medical Leave Act, Employee Rights and Responsibilities. Again, we've kind of showed them a few steps already, but this is a one-pager that kind of tells all employees what is their responsibility versus what is our responsibility. For those of you who do human resources, you probably know a lot of employees may slack off on what is actually their responsibility, how they bring in paperwork, documents. This is basically a clear summary of what we require for an employee to be on leave, and if they are on a leave of absence, what they have to do to ensure their benefits continue. Because most of the time, if someone's going out for 12 weeks, at some point they become in an unpaid status. And that's when it is their responsibility to pay their medical contribution to our Department of Finance. They have to understand what they are responsible for and keep track. We have found the more information we give our employees, and I'm a firm believer, you give this all to them because you want them to go out on leave with peace of mind, first of all. Second of all, if they are having serious health condition or have a family member, many times just talking to them through it, they don't remember things. So you have to kind of hit them in a couple different ways so that they can refer back. Of course, we also, besides us verbally telling our employees what they have to do, giving it to them in a narrative, we still, of course, answer their questions if they call or they email us. Everyone, as we all know, learns differently. But again, if you can reiterate the different ways and they hear it a couple different ways, most of the time it's smooth sailing when they go on a leave of absence. The next form is the actual application for family and medical leave or personal medical leave. Mostly we use this just for the family medical leave, and we have them fill out this if they're going, and this all stays in our possession because we run the time. We kind of ensure that an individual is eligible. That's all done at our office. We do that in-house, and we, if they're going on a full leave, though, we send this application. Yeah. Right. If it's in an unpaid status, we have to send this application over to the Department of Finance, who then handles the payment of health benefits. But intermittent, this stays at our offices in a separate file, their FMLA file. Okay, so here is where you can actually see, this is the certification we talked about earlier, that there's two types of certification. The first one is, let's see how many pages we have here, 4 pages long, and we can kind of go through it. This is to be completed by the employee who has a serious health condition, okay, because there's a different certification if you're taking care of a family member. So again, as you can see, this is basic information on the first page that needs to be completed. What we tend to also give our employees is a job description for the individuals leaving. Don't we tend to give job descriptions with them? Yes. Yes, we give their job description with them. Yes, it's attached so that the doctor understands what their responsibilities are at work. Now, if they're going out on a full leave, the job description really doesn't have an effect when they go out on leave. It's more so when they're returned to work, so the doctor understands if they're returning them to full duty, the doctor knows exactly what their responsibilities are. So the first page talks about, employee fills it out, and then we start looking at what has to be completed by the healthcare provider. If we go to the second page, you can kind of see this is again where the doctor is completing all this information. They're indicating when this condition commenced, how long it's going to be, what kind of treatment this individual. This all is based on what type of leave the individual is requesting. So if an individual is requesting a full 12 weeks out of the office, the certification should match that. It should have a start date of, for example, if they're having surgery, it should start the day of the surgery or a few days before, and then on a typical, a doctor will put what is a reasonable amount of time for that health condition to be out of the office, and they'll write in there, how long they should be out. If you're getting something that doesn't make sense, you're able to go back to the employee and ask for clarification. So, I think a lot of individuals get very gun-shy when we're talking about health issues because of HIPAA and other issues that may come up. But again, if the health provider is not giving you clear answers to this information, it's very difficult for you as an employer to decide if this is a serious health condition and it warrants FMLA. So again, you don't have to be, harsh with the employee. You just have to say, it's not really making sense. I need some more information before we can approve you for FMLA. I can also tell you, in speaking from experience, there's very little time that we can actually deny, or we have been unable to deny FMLA. So you also have to keep that in mind. I think we could probably count on a handful that we may. Yeah, and it's basically due to the eligibility requirements, not based on what the medical provider has submitted. It's really because they just don't qualify for the eligibility. So again, you want to, these medical facts. I do want to point out, which I have on our tips for administering FMLA, I highly, highly recommend that an individual, you assign one individual, 1 to 2 individuals to be responsible for Family Medical Leave Act. If you have too many people working on this, it just becomes very convoluted and difficult. So there should be one, I would recommend one point of contact for your agencies where employees can go and ask for FMLA documentation, someone who tracks it. For example, in our department, as I said, Suzanne Gomez is our point person, and I am her backup. And her and I work on these cases quite a bit together, but she's really the face of the FMLA for our department. If we have issues or concerns, that's when she brings me in and we kind of work through what are some of those issues. Because you also have to have these files protected. They have to be locked up. They can't be out in open areas because of the reason we're talking about healthcare conditions. So, for example, in our Human Resources Division, we have our personnel file, we have a medical file, and then we have FMLA files, because most often times the FMLA files are active files. The individuals are currently on it. When they have closed, we tend to move them over to the medical file and keep it in that separate area. But they need to be locked up. They can't be anywhere where anyone can reach them easily. So those are a few things that you have to keep in mind. I also think if you maintain it to 1 or 2 individuals, depending on the size of your delegate agency, these are topics that you can't say, oh, Sally's out because she's having heart surgery. You can't really talk about those kind of things. You have to say, if you're talking to Sally's supervisor, you have to talk about Sally has a condition that requires her to be on FMLA. She will be out X amount of days or weeks or whatever the case is. There should be no conversation between HR and the supervisor, or even for that matter, the supervisor asking the employee what type of condition they're going out. Those are all HIPAA no-nos. So as you can see, I'm kind of going off subject, but I think we'll kind of touch upon that again about when we go to tips for administering FMLA. But if you go to page 3 of this certification, you can see the doctor, there's a section where it says amount of leave needed. And then if you go down farther on that page, it's additional information from the doctor. And then lastly on page 4 is where the doctor actually signs and dates it. So this is the document that comes back with the full packet. And this is the documentation that the time ticks for 15 days. You give the employee 15 days to be able to complete this information. The other document that I have in here is very similar. The only difference is that it is a family member's serious health condition. So the serious family member's doctor is the one completing this information. But basically asking the same information except, you know, who is taking care of, who's leaving. You can kind of see that in the first page that, you know, the relationship and things like that. So that's what you're going to focus in on if it's for a family member's serious health condition. So that's, again, 4 pages, and you're looking for the healthcare provider to sign off on that. And then if you look at the next page after this certification, if it's going down, Victor. Yeah, here we go. So this one is family and medical leave authorization for recovery of cost coverage. This is basically talking about if an individual has to pay their financial, the financial side of their health benefits. So if they don't return, you know, you can read through it and see, but this kind of covers you to ensure that the employee knows it's their responsibility to pay their health care costs. So for example, if someone is out on leave for 12 weeks, but they need another 4 weeks outside of the FMLA allotment, that's where this recovery of cost coverage comes in. Because after that 12 weeks, their medical coverage typically goes up. For us, it goes up to COBRA costs. You know, the full amount of what an employee would need to pay occurs after that 12 weeks of FMLA. During FMLA, they're paying the same benefit cost that they pay if they were working. After 12 weeks, the costs rise, and that's their responsibility. Yeah, and this is also saying that we can go after the employee to ensure the employee pays that money back. So, yeah, if they don't return. So if an individual goes out for 12 weeks or longer, we can go after them to reimburse us for those health care costs. So again, I would recommend reading through this to see, again, it's City of Chicago, but this is a sample. So there may be something that you want to do to, if you don't have a process already, to make sure this is part of your process. The next page we have is we are required, on top of an individual requesting FMLA, we also have to put them in a leave of absence status for payroll purposes. So this is kind of a form that we require an employee to use, and it's issued, or it's filled out every 3 months. So we do 3-month increments for leave of absence. Majority of, or our staff who are covered by a bargaining unit, they have up to 1 year of leave of absence. So they can go on some FMLA for 12 weeks, but then they have another 9 months to be out if they need to be. Non-bargaining unit staff, we typically offer the same issue. It's very rare that we have an individual, unless they're really ill, to be out that long. But there are, you know, certain benefits that we have to follow, and one of those under the bargaining unit is up to 1 year of leave of absence for our bargaining unit staff. That may not be your case, so I just included this to know that this is also part of our process, and it might be something that some of you with delegate agencies may want to use. So that's kind of a complete packet for an employee who is requesting FMLA. There is one set of another set of forms that I just want to show you that we utilize. It's a little off topic, but can be used concurrently. That's that far left one, Victor. Yeah. So this is where we utilize healthcare provider certification, or an employee sick leave certification, or a return to work. These are used so that an individual, so for example, we had, I'll let you know, let's see, it was the Monday after New Year's, I think, when we had that very cold snap here in Chicago. And we had some employees who wanted to say they were sick on that day. Just interestingly enough, they were sick on one of the coldest days of the year. So to ensure employees are using their sick time for sick purposes, we required them to complete an employee sick leave certification. And Victor, if you go down to the next page, that shows, yeah. So this is where, you know, because sometimes employees don't necessarily have to see a doctor when they're out ill, and that our rule is that we require an employee to come back after 3 days of absence with a return to work from a doctor. Sometimes, though, the employee doesn't see a doctor in those 3 days, and we understand. I mean, there's several illnesses that you just feel lousy and you don't necessarily need to see a doctor. That's when we allow them to use, we ask them to fill this form out so that they're stating that I am using sick time for sick purposes. It kind of puts the employee on notice, and then supervisors, and it may sound like, you know, we're trying to get them in a aha or I gotcha mode, but you know, sick leave is a benefit, and it should be used for purposes for that reason. And my personal opinion is, if you've been here for 20 years and you have no sick time, then you've been abusing sick time, unless you are, you know, have had a serious health condition. So I think that's kind of the route the city has been going in the last few years. So we really want to make sure employees are following the rules, and some of these forms just reinforce our policies. The other thing is the third form on this document, if you go down one more, Victor, is also a return to work certification by a healthcare provider. So we also use this for reasons, let's say an employee says, oh, I have to have eye surgery on Friday. It's a one-day outpatient. And they're disclosing the illness. It's not the supervisor is asking or anything, but they have indicated that they are going for some type of, you know, eye surgery. That is when I advise supervisors that an employee should bring back this return to work certification. If you know an employee is having some serious procedure or something to that effect, you really want to make sure the patient is okay to return to work. So when they're telling either your supervisor or they come to HR, you could give them a form like this and say, you know, when you return, we just want to make sure your doctor is saying you're okay to return to work, either with or without restrictions. And this just kind of gives you the clearance that you know they're able to return to work and that they're not coming back too soon. It's just really a protection for the employer. So lastly, I just want to go over some of the tips for administering FMLA. No, there's one more like this too. Yes. Yeah. Yeah, there we go. Okay. So this is kind of the summary of what we just talked about. Tips for administering FMLA. Again, I highly recommend you identify someone at your agency, one or two individuals who are who should be administering, FMLA. Who is that individual that these employees can go to? No, I'm sorry, that's down the line. I'm saying identify if you are an employer who should be administering FMLA. So basically you want to find out if you have 50 or more employees, 50 more employees within 75 miles, you're a public entity, whatever that is. You want to make sure that you are an employer that must provide FMLA. That's your first step. My recommendation, second step, would be to make sure you go to the website that the federal government offers and to review all the material there. It really is a great website. It goes into a lot of different information. Some of it may not apply to some of your employees, and then you can skip over that part. But I really think there's forms. They update them there. You can also look to see if you, as I spoke earlier about getting a rep from DOL to come out and talk to you about this subject. Thirdly, I recommend you create a policy around leaves of absences and how FMLA will be administered at your delegate agency. Some of the things that always come up, will you require an employee to take all paid time up front, or will you allow them to disperse it throughout the FMLA? We kind of talked about a little bit like that early in the webinar. Most employers require or encourage employees to use all paid time concurrently with FMLA. The city allows it. If people are using paid time, they must use it within the first part of their FMLA. We cannot have them out on a leave of absence and then stack their vacation time at the final 6 weeks. They must use it concurrently at the start of their FMLA. Another question that comes into how you administer your FMLA, there's an option that you can use either the calendar year or a rolling calendar. And this is usually based on your payroll system. The city uses a calendar year because we wipe everything clean in terms of paid time at the end of each year. The next recommendation I have, or tip for administering FMLA, is you assign 1 or 2 individuals who can be considered experts. And I'm quoting experts because I think experts in terms of how to administer, the understanding of what FMLA does for an employee. And this helps ensure that they administer the leaves for your agency following all the rules that are established under the Department of Labor. That 15 days, you're tracking who requested paperwork and when that clock starts ticking for 15 days so that you don't have someone asking for the paperwork in June and then bringing it back in October saying they want to start their FMLA October 15th. You want to create the process where you document the following. Again, who asked for paperwork, deadline to return paperwork, create that packet for the employee with all relevant documents, and be consistent with the process. And then lastly, all medical documentation needs to be in a file separate from an employee's personnel file and needs to be secured at all times. That is huge. One last thing that I don't have on here, but I neglected to mention is a frequently asked question is, when is an employee required to request FMLA? Well, ideally, we want individuals to give us as much notice as possible. Some of those cases you're able to do that. So for an example, if an individual is pregnant, that individual, or if a dad is expecting a baby, you kind of know that ahead of time. We ask those individuals to come at least 60 days before the time that they are going to either give birth or be out with their child. It also is a peace of mind for an individual who is actually having a baby, because when you have the baby, unless it's comes early, you really want that peace of mind. You want to know, I can go into the hospital and everything's taken care of at work. Having a new child, a new baby in your life is already can be very stressful. So you want to be able to assist your employees to make that transition very easy. We also ask if an individual is having some kind of surgery or procedure. 30 days is another ideal time frame for individuals to request FMLA. But then you always have individuals who may need quick turnaround. They're having an emergency procedure, or those individuals who were placed in the hospital on an emergency basis. That's what you have to set up to make sure people know who to call. If supervisors receive that kind of call, who they need to contact to let HR know that those individuals are going to be out for a period of time. Trust me, we have seen cases where an individual is out for 2 weeks and we don't know until 2 weeks into their leave that they've been out. We've really, that was in the past. We've really moved out of that. But it's very easy for an employer, a supervisor, to not realize how important it is to communicate that information back to HR, unless you're at the same location. For us, we have several different locations, so I don't see all of our employees on a daily basis, nor am I in the same location as our employees. So I rely on supervisors to communicate that information back to us in HR. So all of this is to say that FMLA is a very useful tool for supervisors and for those individuals, particularly employees, who need time away from the office. Again, you have to be careful so it is not abused, that you are very consistent across the board with your employees when offering FMLA, and some of these tips, I hope, will assist you with creating policies and procedures around this law. As Victor has typed in, we will be posting these documents so you can use them. Again, I ask if there's anything that says City of Chicago or Department of Family and Support Services, you remove that and create that, customize it to your agency. But I really do think we've created some good forms that may be useful to you, and I hope this webinar was useful to you. So I really appreciate all of you taking the time to sit on this. As I said, I got you through pretty quickly.